Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every other week, community conference call every Thursday. Please note that this call is subject to the disclaimers you heard when you logged into the conference. Information is provided as best as we can. Accuracy is not guaranteed, does not establish attorney-client relationship. This is not a substitute for an in-depth consultation. As usual, I will begin first with the frequently asked questions, ask if there are any follow-up questions on those, and then I will return to the normal questions that are not frequently asked. Again, ask for follow-up questions. At the end, if we have time remaining, we will take on new questions. Let me just make sure that you folks can hear me okay. So let's just check that.
The conference is now in conversation mode.
Can you all hear me okay, folks? Can you hear me all right?
Yes.
Thank you.
Yes.
Thank you, sir.
The conference is now in presentation mode.
So the first question that I'm being asked is, should we remain in H1B status while adjustment of status is pending, and when to file a supplement J? So first of all, I agree with, as you say, most lawyers. I do not think you should let your H1B or even L1 lapse just because you have a 485 pending. There are times when things go wrong with the I-485. We have that happen in about 1% cases, but it does happen. And when that happens, it becomes a very difficult problem to deal with. Why? Because upon denial of your I-485, adjustment of status, you are running unlawful presence. So if you filed a motion to reopen or even a litigation, it becomes complicated because the 180-day period clock is running. If we are not able to resolve it within 180 days, you are put in a very unenviable situation where if your request is not granted eventually, you could be subject to 3-year bar from getting a green card or coming back to the US. And if it goes on further, goes on up to a year, you could be messed up for 10 years. So it's such an easy thing to maintain your H1B. And one thing I want you to remember, if you have an H1B and an adjustment of status, many of you do, and let's say that you're traveling on advanced parole, the law says if you travel on advanced parole, you're not required to get an H1B visa to come back. If you come back to work for the same employer, you are still considered to be on H1B even though you used your advanced parole. So there really is no reason why you should not be activating or keep your H1B activated. As far as the 485J is concerned, I'm being asked my opinion about whether we should be filing it ASAP or should we wait for the RFE, etc. I personally feel that the adjustment of status supplement J should be filed as quickly as possible. I think it gives you additional protections. I have seen them procedurally as much better. Time is relatively limited here. I cannot go into all those details, but the bottom line is, if I were given a choice, I would file a supplement J as early as I can. Unless you call me and tell me, look, I only have a 3-month project or I have a 6-month project. In that case, I will not file a supplement J. I'll wait until you tell me, okay, I'm going to stick at this job for a couple of years. Okay? Because you can file as many supplement Js as you like, but your lawyers are going to charge you money each time, right? So why waste money? *5 if you have a follow-up question on this. No new questions, only follow-ups, please. *5 if you have a follow-up question. Okay, let's go on to the next frequently asked question. This is another one, quite problematic. So there are 2 dates based upon which green card applications move. One date is the date for filing, and the other date is the final action dates. Your CSPA protection is covered by the final action dates, the visa bulletin dates when they become current. So let's say I filed today and my son is 20 years and 9 months old, and I filed based upon dates for filing, which means final action dates are not yet current. Now, if this young man turns 21, even though his 485 is filed, he's not protected by CSPA, but his application must hit, or his dates for his final action dates must become current before he turns 21. If they slide back again, that's not a problem. But for one time, they must become current. Okay, so this is the law. Do you have any questions, guys? *5 if you have a follow-up question on this. I'll deal with the new questions if we have time remaining, and we should. Okay, let's see if there's any other frequently asked question. I don't remember. Here's another one. Oh yeah, this is an important one, and this is something I always brief all our clients. So when you are going for a green card interview, what kind of questions can be asked, what goes on. So let's split this into two different parts, employment-based and family-based. Employment-based interviews, they can ask you about the current job. What are you doing right now? They can ask you about the future job, if your green card is based upon a future job. Sometimes they can ask you for a past history. It can happen that, I have seen that happen, where one of the past companies you used to work for ran into some difficulties with the law. Next thing is they are holding on to your green card. Actually, I'm dealing with one case like that. Last month we dealt with 2 cases of naturalization running into problems because the companies that processed the green cards were in hot waters with the government for fraud and corporate problems. Actually, one of the companies is quite well known. So this can happen. My instructions to our clients are very simple. Remember 3 rules, both for employment as well as family-based I-485 interviews. Number 1, always tell the truth. Even if you are worried that the truth is going to get you in trouble, you tell the truth. Because if you tell the truth, maybe you'll get into trouble because of some problem in the past, but most of these problems are resolvable. If you tell a lie, and you will be caught eventually, that's a permanent bar from entering the United States. Not only that, when you go for the interview, you are put under oath. And if you lie under oath, that's perjury. Penalty of perjury, as I remember, is 5 years in prison. So it's a very serious crime. Therefore, always tell the truth, number 1. Number 2, it is perfectly okay to say, I don't know or I don't remember. If you don't know something or you don't remember something, that's okay. This is not a viva examination where you are required to know all the answers. Whatever any normal employee would know, that's all you are required to know. And even if you, as a normal employee, don't know something, it is okay to say, I do not know. You'll be surprised how many people have difficulty saying that because they think that they need to reply. If you do reply, and you're not sure, you can say, I'm not sure about the answer, but I'm guessing that it may be like this. Okay? Or my best remembrance is this. I don't remember exactly. So it's okay to phrase it like that. It's okay to say, I don't know, I don't remember, or to phrase it with a prefatory remark that I don't remember exactly, but I think it is this. And the third thing that you need to remember, it's always okay to say, I don't understand the question. Could you please ask again? So it's okay to always tell the truth. It's okay to say, I don't know, I don't remember, and always ask for a clarification if something is not clear. Other than that, you are fine. *5, if you have a follow-up question. *5. Okay, doesn't look like we have any follow-up questions. Let's go to the regular questions that are not the frequently asked questions. Regular question number 1, USCIS background check process for 485 and when to contact. So here is the problem. The problem is, and we had a very lengthy litigation with the USCIS under a class action many years ago, and I had one of their officers sitting across from me in a deposition, which is a court proceeding in which they are put under oath, and I asked them questions. The guy didn't want to answer my question. I said, well, how many background checks do you conduct? Well, there's the FBI check, and there's a lookout list check, and there's this check, and there's that test. They said 3 tests at that time. I asked him, I said, how long does the lookout list test take? Well, it depends upon he wouldn't answer my question. I said, okay, how about, can you tell me if it takes 1 minute, 1 day, 1 month, or 1 year? Would you believe it? The answer was 1 minute, because it's just a query on a database. So most of their tests are just querying different databases. But sometimes what happens is your name could be similar, or something in your background could be a problem area where somebody has to physically go and investigate the facts. That can take forever, 6 months, 8 months, 10 months. Okay. And no amount of going to the congressman is probably going to help that. It doesn't hurt to try. You can definitely try. Okay. So *5 if you have a follow-up question, *5 about background checks. Okay. So EB3 downgrade and project with the end client ended. Green card process repercussions. This is question number 5. My current project with the end client has ended as of end of July. I do have a green card EAD from a downgrade. Am I in good standing? Yes, because you have an EAD. Okay. Are there any repercussions for the green card? No, there shouldn't be. The only thing I would be worried about is, does the employer have enough money to pay you? In other words, if they are called upon to show ability to pay the wage that they have indicated on your green card application, are they financially solid enough to be able to ward that off? Can you file for unemployment if the employer lays me off? And that's a very tricky area of the law. Mostly when people are on EAD, I think they can, but do check the local laws, because this is a state law issue. It really is not a federal law issue. So unemployment can be claimed as long as you have some status such as work authorization. EAD allows you to work independently. So it's a good place to be. No problem there. But does the local law allow you? And if it does, go for it. It's absolutely no problem. *5 if you have a follow-up question. *5. Okay. This one is from area code 805. Hi, 805. Where are you calling from?
I'm calling from Illinois.
Illinois. All right, sir. How can I help you?
Yes, sir. So I filed for the downgrade, EB3 downgrade.
Right.
So I got the EAD with me. But if I want to maintain the H1B, and since this current project has ended, is there any issues while I on the lookout for the next engagement?
What you can do is this. Remember, even if you run out of the H1B status, that does not mean the status is gone forever. It can always be reawoken. So let's say that you didn't find another job for 90 days, and then 90 days later an employer comes along and says, look, we want to do an H1B. You can start working with them on your EAD. Have them process an H1B, which will be processed for consular processing. Whenever you get the time, you can go get your H1B visa stamp. When you re-enter the United States using H1B visa, you are back on H1B. Understood?
Yeah, okay.
All right.
And one more question related to that. So if I change employers in the process, since my I-140 is still not approved, will they have to file a new I-140 for me in that case?
Well, first of all, if your downgrade is approved, you should be able to use AC-21 to port over to a same or similar job. But if the I-140 is not approved, it gets tricky. I want you to set up a consultation with your own lawyers or with our office. I will need to look at all your facts before I can give you that answer. But the bottom line is, if the I-140 is already approved, then you are free as a bird. 180 days, 485 pending, I-140 approved. You're good. Okay?
Okay, great.
Good luck.
Okay, thank you so much.
Oh, you're welcome. Okay, let's go on to the next question. So this is a complicated history. I'm not sure I understand it completely. But return to the original green card sponsoring company after 1 year with another company, naturalization process issue. I lost my job in 2020. My L1A sponsoring company did a business restructuring. At that time, I-140 was approved and pending 485 adjudication. I chose AC21. I moved to, oh, hang on one second. There's another question. I just saw that. I'm not taking new questions. Area code 415. I'm not taking new questions. We'll do that at the end of the discussion. So if you have a new question, please wait until the end of the discussion today. Okay? But if you have a question related to H1B and 485, I'll just unmute you 1 second. Area code 415, where are you calling from?
Yes, sir, California.
All right, sir. Go ahead.
So, sir, the question is about H1B and 485.
Sure.
If the 485 and 140 downgrade has been filed by the previous employer, and the current employer is due for an H1B renewal, and 140 is approved for the downgrade, should we wait for the H1B renewal or process it with the 485J?
You know that H1B is not disturbed by the 485 or the 485J. So really, these are two parallel lines that never meet. You can process the H1B completely independent of where you are with the 485.
Okay, so because I have not received the EAD yet, so I cannot work with the current employer under the adjustment of status application. But they are willing to renew my H1B.
You can file the H1B, and if you are past 6 years, you might need to explain why you are filing for an extension when the dates are still current. And the answer is, I filed my 485, I still need my extension. I think you'll be fine. I don't see any problem with it. Okay.
Okay, thank you, sir.
You're welcome. So going back to this, so then after the L1A, I moved to another employer. New employer filed supplement J in July of 2020. I received my green card in September 2020 based upon the 485 sponsored by my first employer. But you already filed the supplement J. The supplement J was closed saying that you already received the green card. Is this okay to join the old employer again? Absolutely fine. I don't see any problem at all. In August, I got, that's perfectly fine. I worked for the second employer for more than a year, and even if I count the number of months after second employer, I don't know what you're worried about, Kiran. You're fine. I don't see any problem with it. Will it cause any problem during naturalization? I can't think of a single reason why. *5, if you have a follow-up question, it looks okay to me. Absolutely, it looks fine. Okay, very good. Let's go on to the next question. So, impact of H1B overstay after I-797 expiration. You did your master's in USA. You worked with Company X until December 2016. Then you got laid off. You have pay stubs till December 2016. They filed for you, next company filed for you a couple of months later, February 2017. In the last week of May, I-797 was received, validity period starting from November 2016 to January. So that's one thing I don't understand. They gave you retroactive approval? That's unusual. my employer and lawyer suggested me to leave the country as they never faced this kind of situation. I stayed until December 2017 to try my luck. I don't see any problem. I'm unable to see a problem here. *5 if you're on the line. Please press *5. I'm confused about what is the problem. Why were your lawyers concerned? This makes no sense to me. Sir, I would like you to set up a consultation with your lawyers. And if they are not able to answer your questions, you're welcome to reach us for a consultation. I don't understand the problem. I see I think it looks to me like you're perfectly fine. In the first week of May 2017, the I-797 was received with validity period starting from late November 2016 to late January 2017. I see. Oh, okay, maybe that's the problem. Because you got approval till 2017 January, but you received the approval in the first week of May of 2017. I see. So basically what happened was you received approval 5 months after the approval had expired. And this has happened to us too, by the way. And we were able to fix it. I don't remember exactly what we did. It just happened a couple of months ago. So we figured out this is the way we're going to fix it. We were able to fix it. Because this is really their fault. They are informing you 5 months after the fact that, oh, by the way, you've been unlawfully present last 5 months. That's nonsense. Okay, so the thing is, you stayed till December 2017. So the problem is from January 2017 to December 2017, you had no authorization. Yeah, this I understand now the problem. So it looks like potentially, of course it can be fought, potentially you are subject to the 3-year bar and your wife could be potentially subject to the 10-year bar. I don't know all the facts, I'm making a guess. I just want you to look into something called a 212D as in doctor 3, 212D3 waiver. Google it. I think you should be able to get a 212D3 waiver fairly easy. What a 212D3 waiver, or I shouldn't say that. You should be, at least I think you are qualified. 212D3 allows you to stay in the United States even though you are serving unlawful presence time. So let me give you an example. Let's say you've got 3-year bar from entry. Okay. You got the 212D3 waiver in 2021. You can come in on the H1B visa even though you have a bar. In 2024, 3 years later, the bar is gone because you've served your 3 years even though you served them while you were inside USA on an H1B. So 212D3 is a very effective tool if it works. *5 if you have a follow-up question. *5. Yeah, I think this is a lawsuit waiting to happen. Because the government should not, your wife does not have an excuse, but you do. At least that's the way it looked to me. It looks like to me. Okay, so obtaining visas when denied entry to the US after 10-year ban. So this gentleman or lady has already spent 10 years outside the US. Okay. What will happen if I'm going to the US as a Canadian citizen for leisure or work-related reasons? Okay, so if your citizenship requires you to apply for a B1, B2 visa, where there is a question on the DS-160 that have you been out of status, you'll say yes. Have you been unlawfully present, you'll say yes. Once they find out that you've been outside 10 years, you're good as gold, no problem at all. So would US immigration be cross-checking based on name, date of birth against the list of those who were the subject of 10-year bar? Well, if you said you are subject to 10-year bar, but the 10 years are already over, so what's the problem? You should be fine. So once they know that you've been outside USA for 10 years, you'll be fine. If I'm traveling by air, US immigration is located in Canadian airport. I'm still on Canadian soil. Can I just turn back? Yes, of course you can if they deny you. No problem at all. Even if you are in the US, you can turn back. If coming by land, you can just turn back too. I don't remember what the rules for Nexus are, but that's something you'll have to look at. Something else I should know or prepare for? Yes, carry evidence that you have been in Canada for 10 years. Leases, credit card payments, utility bills, offer letter or job letters from employers. Carry proof that you've been in the in Canada for 10 years. Tax returns, whatever else you can think of. Okay. Star 5 if you have a follow-up question. Star 5. All right, let's go on to the next one. Can US citizen parents file for permanent residence for son and daughter-in-law? Daughter-in-law, no. Son, yes. And remember, green cards can be applied in multiple categories at the same time. Isn't there a category for adult son of a US citizen? I think there is. But the category is backed up like 8-10 years, something like that. So it may not be worth much, but they can certainly file for you. Okay. And I think your wife should be able to get it directly as a derivative, but they don't apply for her. That's the way the process works. They can't file for your wife at all, so there's no question of separate petitions. Star 5 if you have a follow-up question. Star 5. Okay, let's see what the follow-up question is. Area code 551. Area code 551. Where are you calling from?
Hi, Rajiv. I'm calling from Houston, Texas.
Mm-hmm. Go ahead.
So we just wanted to make sure that we can file to parallel I-485.
Absolutely. You won't have 485 unless your priority date is current, which is not. So priority date will take a long time. You'll file the I-130, not the 485.
And is it okay if my father and mother file separately for 485? Like, because
not 485. Hang on. They can both file for you I-130, not 485. Okay.
Okay.
What else?
So, like, sometimes we hear that if some father or mother pass away, the file closed out. So they are trying to put separately.
Yeah, well, if in case somebody is living in the United States and their sponsor passes on, there might be an option called survivor benefits. You can look at that. There's also something called humanitarian reinstatement. So in any case, I think you're going to get your employment-based green card before you get your I-130. So it's a useless discussion. But yeah, you can certainly file. You can file. Mom and dad can both file for you, no problem. Okay?
Okay.
Good luck.
Okay. And
Sir, I got to move on.
Think
Yeah.
Just last question, but it would not benefit anything for this employment base.
No, I don't think it helps. Okay?
Okay, thank you so much.
You're welcome. All right, so we covered this already. AC-21 portability after more 180 days. I-140 and 485 pending for more than 180 days. Will a pending 140 be approved as I left the job due to layoff? No, that I-140 can be denied actually. Normally, the government should look at what was the situation on the date the I-140 was filed. Okay, but until the I-140 was approved with the 180-day period, you are not protected. They can get an RFE. If there is an RFE, they may not respond, your employers may not respond. Once the I-140 is approved, the fact that you even if you left should not be a problem for you. Okay. Star 5 if you have a follow-up question. Star 5. Okay, this one is from area code 818. That's California. Go ahead, please.
Hi, Rajiv.
Rajiv. Thank you for doing this. So I understand your response. My question is that so the 140 is filed by a big corporation. So I understand the RSC situation, but I understand the worst case situation as well. But I wanted to see if there would be a chance of 140 approval, or if 140 will be purely RSC or denied just on the basis of me leaving the job within 180 days.
Leaving the job is not an issue. Okay, we actually have tested this in court. Even though there's plenty of policy statements on this, we've even tested this in court. So leaving the job is not the problem. I-140 approval is the problem. Okay.
Got it. But would 140 still be approved?
Yes. Yes, it happens all the time. Absolutely. Okay.
The only concern is the RFE situation.
Yes. Yes. RFE or the employer going out of business?
Okay, so employer won't go out of business. RFE probably will not have anything to do with me leaving the job, right? It could be
no, it should not. It should not. Okay.
I'm sorry, could you repeat that?
It should not have anything to. It should not, sir. It should not have anything to do with you leaving the job.
Okay. So anything that's not related to that, let's say some document is missing, some proof is missing,
right,
could be related to that.
Or ability to pay wages, tax returns, anything like that.
Okay. So this is a big corporation, Rajiv. So none of the.
Hopefully.
Could this be an issue?
Hopefully, but they can ask for anything.
Hopefully.
Yeah. Okay.
Okay, got it. Okay.
Good luck.
Okay, thank you so much.
You're welcome.
Thank you.
You're welcome. Bye-bye. Daughter's passport renewed, I-94 not updated. So the most important thing, Mayank ji, is if you are here, press *5, Mayank. I'm assuming that your daughter is under, 18? Yeah. If she's under 18, there is no unlawful presence. So you should be able to get, let's see, I-94 have now renewed her passport. You can contact the Customs and Border Protection, especially if she's a minor. They may be able to issue an I-94 locally. It doesn't hurt. Or even go to the border and come back in if she has a visa on her passport. Okay. Yeah, you can certainly ask a CBP office. You can also apply for an extension, pleading extraordinary circumstances. As long as she's under 18, there is no risk of unlawful presence becoming a problem. So definitely all these options are available. Okay. Any follow-up question on this? Traveling outside the country on advanced parole when 485 is pending. We plan to travel to Mexico. You cannot travel when the advanced parole is pending. Okay. So even if you have an H1B visa stamp, if you travel, the current thinking is you have to apply for an advanced parole again. EAD is okay to stay if you have an H1B visa stamp, but your advanced parole will have to be refiled. *5 if you have a follow-up question on this, press *5. Okay. Let's see. This is from area code 214. 214, where are you calling from? 214. Hello?
Rajiv, can you hear me?
I can hear you. Yes, sir.
This is from Dallas, Texas. So, sorry if I was not really clear. My AP has also been approved.
Oh, good.
In this scenario, so, yeah.
Oh, sorry. AP is approved. I misread. My fault. You are right. We plan to travel to Mexico for a short vacation. If we could enter our AP going to the same employer, if yes, the answer is yes. Beside our combo card, my kids 512, do we need to carry other documents? They can ask for pay stubs and all. It's just as easy to carry them. Why not? If I were you, what I would do is I would scan these documents and upload them to the cloud so that you can access them on your phone if necessary. And that should work. Okay.
That sounds good. Thank you, Rajiv. Can I ask another question?
Sure. Go ahead.
So what had happened was, after writing this question, I realized that my son's EAD wasn't filed, along with ours. So we only have his AP approval.
Yeah. You don't need EAD. How old is your son?
He's 16.
Okay. Is he going to work?
No, not at the moment. But then,
okay.
Other than
hang on. Let me sum up the law for you. First of all, he does not need an EAD to travel. He only needs an advance parole. So going to Mexico is no problem. When he comes back, if he wants to work, you can just apply for his EAD. No issue.
Sounds good.
All right.
So even if at this point, if my attorney is willing to file his EAD, that should be totally fine, right?
I believe so, yes, because the government has said that travel outside on advance parole does not nullify the EAD. You should be fine.
Sounds good, sir. Thank you. Appreciate it.
You're welcome. Okay. F1 OPT visa. So your visa has expired. You're going to go for EPT. Never know. The problem is, well, even though you are covered by the national interest exception as a student, but are there visa stamping spots available? Number one, they are trying to frontline student visas, but are they available for you? Number two, is there any guarantee that you will get your student visa extension? Never know. I think you should, but who knows? *5 if there's a follow-up question. Okay. So there are some H1B documents that were lost. Naturalization is coming up. Do they go through the green card approval file? Absolutely they do. More than 15 years ago, I worked on H1B at different locations because no H1B amendment filing was mandatory before the CMAO memo. Yeah, I think you should be fine. Look, you should really discuss this with a lawyer. Go over all the issues that are bothering you. That could be potentially a problem. Your lawyer should take care of those issues, take a look at them, and see if you are protected by Section 245K as in kite when you filed your green card 485. So that should all be compared. Don't file naturalization without having a detailed consultation with your lawyers. Also file a Freedom of Information Act request. Get a copy of all your documents from the government with the USCIS. Okay. That's pretty much it. *5 if you have a follow-up question on this. *5. Any questions, any new questions, press *5. Okay. Let's see how many questions we have. Not bad. Only 5, 6. Yeah, not bad. We can do 6. All right, let's get started. Oh, no, there's 7. Okay. 7. All right, let's see if we can get through them all. Area code 570. Are you calling from Virginia? 570?
Hi Rajiv, this is from Pennsylvania.
Okay. Afternoon. Good afternoon, sir. How can I help you?
Sorry, I just joined late. I think one question got like a FAQ. So that is question number 10.
Okay.
So there is some follow-up for that. I think...
One second. So the questions during the interview process, right?
Yes, Rajiv.
What is your question?
I
already...
Any documents I need to carry on?
Oh, I'm sorry. I should have... Yeah, basically, my recommendation to our clients is always, first of all, go over the list of documents that the notice asks for. Make sure you have those. And in addition, if you have a copy of your entire green card immigration file, take it with you. It doesn't hurt. Why not?
Okay, that means that application the lawyers filed, right? That copy.
The application, past H1Bs, past F1, any document that you can think of. Or if that's a problem, just scan everything, carry your cell phone so that you can go into those documents. It's usually better to carry hard copies because they can look at it right away.
Okay. Okay. And that is for main applicant and for the dependents.
Yeah.
For everybody.
Yeah, I think you should.
And how about you? 140, like the petition, original petition, do we need to carry?
No, they have all of those. Unless the notice specifically asks for a document, everything else is pretty much discretionary. You don't have to carry it. Because remember, if you are missing a document or two, they'll just send you an RFE. So it's not a problem. Okay?
Okay. And also the pay slip and the current employment letter also should be good.
Always.
Like
Absolutely. And make sure you carry an updated employment letter because they ask for them even though they don't put them in the notice.
You mean like the recent employment letter, right?
Exactly.
From my HR.
Exactly. All right.
Okay, Rajiv.
Good luck,
And
sir.
any general questions they will be asking? Like,
Sir, I can't. I have to go on. I've got a bunch of people waiting. So I've covered everything that you asked for. Listen to the recording. You'll get the rest of it. I gotta go. Area code 469. Go ahead, please.
Hey Rajiv, this is Rajiv.
Hi, Rajiv.
Answering the call.
Yes, sir.
My situation is a little bit. I'm on F1. My F1 expired. OPT expired on 6/14/21, June 14th. I filed for my STEM, and meanwhile my H1B got picked from my employer.
Okay.
But I just got laid off this Friday.
Okay.
My H1B is pending and my STEM OPT is pending.
Okay.
So my question is,
They can actually
if the
check
H1B
with your DSO. They might be able to. They should be able to reinstate your service. If your H1 is not yet approved with a change of status, your DSO should be able to reinstate your service.
Right, but my STEM OPT is also not yet approved.
Then you're fine. Basically, just
But what if
yeah,
H1B gets approved
yeah.
and then I got a new employer? Will I be able to file with cap exempt?
Yes, if you talk to your current employer, tell them not to revoke your case, H1B case, until after October 1st. If they do it on October 2nd, you're good. You can go through without the quota problem. Okay.
And also that will be the transfer, but before October 1st, if the new employer
you can do a transfer, and it should work fine as long as the old employer doesn't revoke your H1B before October 1st.
And what if I get approved as an H1, but my old employer tries to revoke it before October 1st, but after the approval?
After the approval, as long as the request for revocation is made before October 1st, you have a problem. If the request for revocation is after October 1st, you're fine.
Okay, so that if it's before October 1st, I'll be out of status, right?
You'll have all kinds of issues. I can't get into all of those right now, but just make sure you talk to your employer. Tell them not to revoke before October 1st. All right?
Okay.
Good luck.
Thank you.
You're welcome. 212 New York. Go ahead, please. 212.
Yeah, hi. So my H1B academic got approved, and so now I need to go back to India for visa stamping and marriage. So which option would you advise? Like first is get my visa stamping, then do marriage, and then apply for
Oh, no.
Or second one is
Oh, no. For H1B, sir, for H1B, it does not matter at all. It's your call. I think it's easier if you go together because she'll be covered by your national interest exception. It's a lot easier. Of course, she'll be covered even if she goes alone, but might as well go together if you're getting a visa appointment early enough. So if you get your visa appointment before your marriage, take it, go get your H1B stamping. If you're getting it after marriage, go together. Okay?
Sounds good. Thank you.
Good luck. I forgot to ask where he was calling from. Area code 224. Where are you calling from? Area code 224.
Hello, Rajiv. I'm from Illinois.
Hello, Illinois. Go ahead.
Hi. So I have a quick question. So I need to give some details. So anyway, I'm actually planning to, rather, I applied as a derivative back in October 2020 through my wife.
Okay.
And so far only biometrics done for us, meaning my wife and my two kids, including me. No EAD yet. So now what has changed is my old employer finally agreed to file my AOS. Okay. So my goal is to file AOS as me as principal, and my wife, of course, will be derivative. Okay. My PD, my priority date, final priority date got current. However, my spouse is not. Okay. So mine is current and hers is not. So I'm just wondering, if I file my AOS, are we supposed to be cognizant of any things we need to do, like,
okay, if you promise not to ask any follow-up questions, I'll tell you what you need to do. Okay, because I don't have time for follow-up questions. You can talk to your lawyers about this, but think about it this way, that if you made a request to the government, my priority date is current, here is my 485, you haven't filed a 485 through your wife yet, right?
I did.
Okay, so you can actually do this. You can actually request the government to convert your pending 485 to primary and her pending to derivative, and you should be able to get, without having to file a new I-485, your 485s reversed and get yourself in that queue. So it shouldn't be a problem. Have your lawyers reach out to the USCIS and as well as send a letter. That's number one. Okay. Number two, you always have the option of filing a second set of 485s. If you have your A numbers, make sure that they are reflected accurately on the new filings. But I think that's unnecessary. Okay. So
unnecessary? The first one is unnecessary?
The second one, filing two I-485s.
Oh, gotcha. Okay.
Okay. Good luck.
Okay. Thank you so much.
You're welcome. Okay. Area code 415. Where are you calling from? 415?
Yes, sir. From California.
Yes, sir.
So, sir, the question is related to the 485 pending. So, it's through my previous employer. A 140 downgrade is approved. We're waiting for the medicals, RFE, and the 485 is pending. Should we interfile the medicals without the RFE?
Yeah, we are doing them. We are doing that right now. We just cannot.
Sir, any positive news on that?
Well, the thing is, it's still too early to say. But what harm is there? I would file it because you can get the doctor to give you 2 sealed envelopes instead of 1. Get the doctor to give you 2 sealed envelopes. Send one now. Second one if there's an RFE.
Got it.
Okay.
Sir, but is it? Some lawyers are suggesting that it may delay your case.
Why would it delay? Why would it delay? I don't understand that. I see no reason for that.
Okay. All right.
Okay.
Sir. Thank you.
Good luck.
That was the question.
Good luck. Area code 469. Where are you calling from? 46.
Good afternoon.
Yeah, good afternoon.
Ramesh from Dallas.
Yes, sir.
Rajiv, I have a peculiar scenario.
Okay.
So this is about approval of a PERM appeal. So the PERM priority PERM was filed in 2012. It went to an appeal, and after 5-6 years, it got approved in December 2019.
Okay.
So this PERM is like prolonged, not because of the person. It was held in the OALJ, right? So when I-140 was filed, the I-140 got denied. Also, another PERM which was approved and there was approved I-140 that got revoked, and the reasons were not very clear.
Okay.
At least for me, the attorney might have got it, but not clear why they would revoke approved I-140, which is in a later date.
Okay.
And they also deny an 140 based on the appeal thing.
Okay. So basically what you're asking me is, it's like asking a doctor to diagnose a patient without looking at the patient. I really don't know what the problem is. But the fact that it has gone through 2 cycles and an appeal makes me wonder if there is a real problem there or not. Okay. So I can't really tell you the answer. I can't give you the answer without looking at the files. But if you have good, competent lawyers, unless you need a second opinion, I don't see any reason for you to spend money on us. Okay. But
okay, Mike.
Yeah, go ahead. Go ahead, sir.
The question is there an expiry date for the perm? So the perm was
Yes. Yes.
on a hold stage for a long time with them.
Yeah, the perm has an expiration date. Once the perm is approved, you have to file the I-140 within 180 days. Okay?
So that was done. The 140 was
Yeah,
filed within
I am
180 days.
see.
I'm asking
Once the perm is approved, there is no expiration. If you file an I-140 within time, even if the I-140 is denied, you can file another I-140 based upon that perm. That perm never expires. First time around, you must file your I-140 within 180 days. Okay?
Got it. Yeah.
Good luck.
Got it. Thank you, sir.
You're welcome, sir. Last question, area code 702. Where are you calling from, 702?
Hey Rajiv, I'm calling from Nevada.
Nevada. Okay. Go ahead, sir. How can I help you?
I recently, about 2 months back, I got my green card through employment EB1C. Now I have a very good job offer from another company. I'm planning to join them in a month. So is there any risk with joining them, in naturalization process?
I can give you an opinion, but I can't tell you the fact. As in my opinion, there should not be any problem. Is it a fact? Well, government can try to challenge it. I don't think they would succeed. All right?
Okay.
Good luck.
Thanks.
You are very welcome. Well, folks, as always, it's great talking to all of you. I'll see you again in 2 weeks. Be well.